Investigation.
I'm grateful. I think I left my submissions in talking about Section 62 and put short, forget receipt. Receipt means payment. Forget entitlement or receipt specifically by an employee. There is nothing in the text of the charging provisions which sets that as a statutory condition. In parentheses, there are provisions which do talk. You've seen examples in Section 62 which do talk about benefits obtained by the employee. There are other provisions which talk about payments to an employee. So far as they are concerned, in my respectful submission, the fulfilment of a bargain by an employer to an employee is a payment to an employee. Why shouldn't it be? Payment means all sorts of things depending on context. If my employer pays my train fare, why isn't that a payment to me? And again, not a rhetorical question. Then, just picking up, please, this notion of, this again connects to questions raised by my Lord Hodge earlier this morning about pension contributions. If the court, please, looks at section 643 of the Taxes Act, it's behind tab 5, and it's MS 1233.
Yes.
MS 1.
1233.
Thank you. Yes.
And the analogous provision for ITEPA is section 308 at 1321. They both say the same thing, and the court can see it. Contributions under approved personal pension arrangements, they're defined in section 630, it really doesn't matter how they're defined, are not regarded as emoluments. So the draftsman clearly contemplates that an application of salary towards anything might be an emolument. And of course it might be.
Has that always been, has there always been a provision in that sense for pension? I mean, when did that first come in, the provision for pensions?
Yeah, I don't know. And again, if the court wants me to, of course I can.
Well, it's been around quite a long time.
Yes.
Well, the footnote refers to the 1987 Finance No. 2 Act.
Yes. If there was a predecessor, then yeah. I don't know.
But you say, in a sense, that supports your argument because it shows that that would otherwise be a taxable emolument.
Or it could be.
Or could be.
Yes.
But is the effect of that then that a non-registered pension scheme would face a charge to tax for contributions going into it as an emolument?
It could.
It could.
And that's all to do with the construction of the contract and the bargain as to whether what the employer is doing is saying, instead of paying you 100, that same 100 is going somewhere else. That's emoluments. And it makes no difference whether that's a pension fund or to buy a house or to buy a car or, as in Heaton and Bell, or anything else.
Approved pension, personal pension arrangements means approved
by the revenue.
By the revenue. So a contribution paid to an unapproved pension scheme how would that work?
It depends. I think this replicates the answer I made to my Lord Hodge. It depends whether or not that contribution by the employer represented an application of the employee's salary, in which case it would be an emolument, all right. It's simply, instead of being paid to the employee, who then makes a contribution to his pension fund, it's paid direct. Or, if it's not that at all, and I'll come to this, my lord, when I look at the cases.
So, yes, I see.
But
So
your
there's
argument is,
a risk it could be taxed twice or not?
No. No, not at all. My big message to the court is that in looking and finding out what the employment package is, one asks, is the reward in this case a payment of cash, bracket, paid to someone other than the employee for reasons of their own, close bracket, in which case taxable emoluments? Or is it something else, something which is other? And I'll show you the cases. It's something which is other when it as a realistic assessment of the remuneration package, what the employee and employer have agreed is not that there is a payment of 100, but rather the benefit of something later on, say, or a suit. So in Wilkins and Rogerson, it wasn't the bargain that the employer would pay precisely 15 for a suit, and that is salary of the employee. The bargain was the employee gets a suit. In Tennant and Smith, the bargain was not that the employer would apply the bank manager employee part of his salary to pay for rent. He was asked to, in fact made to, live in a house. Then the question becomes whether that's taxable for other reasons. But everything, and this is, I mean, I keep saying this, and I appreciate I keep saying it, this really is nothing more than finding out what is it that the employer and employee have agreed will be the reward to the employee for the work that all he's in this case, have done.
But in Ford and McHugh, the revenue's argument was that the payment into the employee's pension, retirement pension scheme, was earnings, as understood in the national insurance legislation.
And this court, and your lordship in particular, held that they were wrong, because you don't assess the quality of that payment as earnings or otherwise simply by finding out whether there was a consequential benefit.
Yes, so something can arise from the employment, but you have to look at what the thing is. That's the distinction you're making.
And put another way, it's not a but-for test.
Yeah.
There has to be a causal connection.
sorry, I'm not sure I'm understanding. You were saying that in this respect, the NIC definition is narrower than under the...
No, I'm not at all. What I'm saying is that in Ford and McHugh, there was simply no analysis that the payment by the employer in that case to the funded unapproved retirement benefit scheme was an application of salary. There was no argument, no analysis of the contract, no analysis of the package. The revenue argued, and they lost, that the payment had to constitute earnings because there was a consequential benefit to the director of the company by reason of the payment into the scheme. And what this court held was that's not good enough. And that could be viewed as nothing more than a standard application of Tennant and Smith. There's a consequential benefit of money being tipped into a fund. That's not enough for that payment to constitute earnings. There has to be a causal connection between that money, that payment, and work that you have done. And that, my Lord Hodge will recollect, it simply didn't feature in the case.
Or was that because the revenue missed a trick then?
Well, I don't know. I mean,
It sounds a bit like-
I've got nothing. I have no response to give your lordship, except if there had been established a causal connection between the payment by the employer and the work done by the director of the company in that case, that because the director has worked, he has earned money, instead of paying him, the company will pay it into a fund, then that would have been a much stronger case, put at its lowest, for the revenue that was earnings.
You say it's not but for isn't enough, it's got to be causal connection.
Yes.
How does that actually work? When would you have a but for but not a causal connection?
Oh, say in this case, the causal connection, as I say, on any, in my respectful submission, realistic assessment of the facts in this case, is that the footballer worked by playing football, the executive worked by doing what they do, the money arose by reason of that work, the causal connection is there and is paid to the principal trust. Everything else happens as what I described as a fructification of that scheme, the application of that salary once paid, so the appointment onto the sub-trust.
I see in that sense it's a causal connection, not but for. The fact that money is then paid out of the trust, but for would be satisfied, but it's not causal.
Absolutely.
Yes, I understand the point.
Absolutely.
Sorry, thank you.
But that is what makes my point, in my respectful submission, good. That's why there's no double tax.
But virtually any sum then paid would be by an employer for the benefit of an employee would then be caught, wouldn't it?
I'm so sorry.
Virtually any sum paid by an employer for the benefit of or because the employee was working for the employer would be caught by your test, wouldn't it? Other than something which falls within section 643.
No, I'd say it was the opposite. I'd say that, take two quite separate illustrations. Illustration one, which is this case, you have worked hard, but to avoid tax or any other reason, I'm not paying you 100, I'm paying Aunt Agatha a trust, which you're happy with because you hope that the payee will lend you the money. That's taxable. There's a causal connection because the money is paid as a reward for work done. Illustration two. Every time my learned friend Mr. Thornhill wins a case, I shall make a donation to charity. That's by reference to services provided by Mr. Thornhill. There's no causal connection. He's not taxed on that amount.
But every time, if you said to him every time he wins a case, you'll pay him,
why shouldn't he be taxed on that?
Exactly, that's what I'm saying. It doesn't have to, my point is that your point's equally good, whether it's paid to him or to a charity.
Yes, but that...
but that's not paid by an employer, though. Are we talking about what I'm talking about?
We're talking about source, aren't we?
Absolutely right.
Right.
Absolutely
exactly.
right.
So any payment paid by an employer would be caught.
Yes, and
right.
That's not odd in my respectful submission. Okay. If the source is the services provided,
sure. Yeah.
Then payments made which have a causal connection to that source should be taxable.
But just in case I've misunderstood, the point I was making was any sum paid by an employer to an employee would be caught.
And I'm saying, well, there has to be a causal connection.
Yes.
That's why there are cases for...
I suppose if the employer just said, that's a gesture of my affection for you or my fondness for you, I give you this money, but that wouldn't be connected with the
There are
employer.
cases, exactly. There are cases to do with testimonials for sportsmen.
But
Absolutely
once it's connected with the work, then...
Absolutely. And in fact, there's a case in the bundle, Pucanoans, which, please don't turn to it, but just for your reference, it is 42, tab 42 of the authorities bundles. Please don't turn to it.
The source doctrine is what we find in section 19.
Section 19.
Absolutely right. Absolutely right.
From.
Yeah, absolutely right.
If I-
The point I make about Pook and Owens is simply this: a reimbursement of the cost, in that case to a doctor, was held to be not taxable. Why? Because it wasn't a reward for services. It had no connection to the work he'd done already, the work he was going to do. The only reason that that payment was made, yes, it was by an employer. Absolutely right. It was made by an employer, but it was paid to the doctor, as it were, in the capacity of someone who'd incurred a cost, and he was being reimbursed. So there was no connection to services, past or future.
Precisely.
And
It was the reimbursement of costs between two places
Yes.
of work.
absolutely right.
Yes.
And that makes the point that, as my Lord Reid has said, that's what, put another way, is a question of source. The source of that payment wasn't his employment, even though it was paid by an employer. The source of that payment was the fact that he had incurred an expense. That's exactly how the court put it.
Yes. I mean, reminding me of Pook and Owen brings back some very unhappy periods trying to work out what the ratio of that all was.
Yes,
Back in the early 80s when I had to do with this on a regular basis.
yes.
I mean, my worry is, I have at the back of the mind, it all sounds too simple the way you're putting it. I'm not quite sure why, but
Well, I think it might be viewed as simple if one were not seduced by submissions that it wasn't simple.
I'm always seduced by submissions that it's simple. Just that sometimes it may sound too simple.
Sound like a reluctant seducee.
Wasn't there a great case? I remember a great case, may have nothing to do with it, about educational trusts and putting money into educational trusts for employees' children and things, which went all the way to the Lords. Doesn't ring any bells, that sort of thing.
No, it doesn't.
Anyway, don't worry. I mean, I'm probably completely on a red herring.
I think Wicks and Firth. Is that
Probably, maybe, yes.
Yeah, I really don't have much to say about Wicks and Firth.
Keep away from it.
But the point's an important one. If one recognises that taxation is a function of source, and in the context of Section 19 and Section 9 of ITEPA, is a function of a causal connection between a payment and the employment, that is a very, very, very useful touchstone to found taxability. That deals with the points raised by my Lord Newburgh. There may be all sorts of payments made which don't satisfy that causal test. Payments made as personal affection, all that. The payments made in Pook and Owen, that too. But in this case, the payments were made to the footballers as a component part of a remuneration package on the basis of which they were recruited. And in this case, the money was paid to executives instead of the bonuses being paid to them to avoid tax. So forget Pook and Owens. And if I may, please then, trail what I'm going to say about the cases. The cases can be divided up into two categories. They can be divided up into the categories where, in finding out, this is where I started, in finding out what was the reward for work done and when was it payable, the two go together, where what in cases like Smith and Stretton and Hadley, what they found was, well, actually, it's a money payment. And it's taxable. In other cases, like Ford and McHugh, like Edwards and Roberts, the reward wasn't that, it couldn't have been that, certainly in Edwards and Roberts. Because whether the payments that were being scrutinised were being made at all or not were contingent. Whether they would ever be paid in any form to the employee was contingent. And what would be paid to the employee, whether it was money or shares, was contingent. So it is not surprising at all in Edwards and Roberts that what the Court of Appeal held was the reward was the shares once they actually emerged. But they've got nothing to do with any condition of an employee having to have actual receipt or of an employee needing to be entitled any more than Heaton and Bell did.
You want to come to Dexter in the Special Commissioners?
Yes, and I can take Dexter short. In Dexter, there was a funding of an EBT, but the trustees were not asked to allocate the funds that had been contributed until after the contribution had been made. So for that reason alone, the diversion of earnings issue would not and could not arise, because the money was contributed to the trustees of the EBT before it had been earned. Because I will show the court and make this good. What happened was, step one was contribution of the money. Step two was then, after that, the employer deciding that for either past or future services, the various employees, there were 6 of them, should be rewarded in various proportions, asking the trustees to make allocations to sub-funds, and the trustees did that.
So the initial payment is to a general fund which isn't allocated as...
On the face of it, yes. And that's what was found. So on the face of it, yes. That's not this case. This case is where specific employees were told, you Mr. McCann, get whatever you got, 8,000 a week. That gets tipped into a trust, etc., etc. You, Mr. Bain, the executive, you get, if we do give you a bonus, that's going to go into the trust, and then we're going to ask the trustees to do
So
something.
the key difference is that here a specific amount of money referable to this employee's employment is paid
Yes.
into the fund,
Yes.
rather than being a general fund.
That's why it's diverted earnings. That's why the money once earned has had, in my formulation, has already been earned by the time it gets dipped into the trust.
Yes, so you say in Ford and McHugh, you were simply in a but-for territory because money was being paid into a scheme, while in section 643, the exemption from being categorised an emolument applies to monies which a employer pays into the specific employee's arrangements.
What 643 is doing is saying, even if that happens, don't worry about it.
Yes, it is not a monument.
Yes. And I don't have much more to say on this point, because if I turn now to the cases...
Well, can I just press you on that? In the case of the footballers, you can say that the contributions being paid into the trust funds are part of a package, a remuneration, I mean, if I can use that term without begging questions, but anyway, a package agreed between the footballer and the club, rather than being an amount which the employer decides ad hoc to pay depending on its own view of matters. But the position of the executive's bonuses might be distinguishable.
Not relevantly in this case, because the paragraphs of the FTT's decision I read out, 12, 103 little 5, also as it happens in paragraph 41, there was a practice of paying discretionary bonuses, money. And if I, the employer, if I, Rangers, had paid you, the executive, that would be taxable. There was discussion. That's 103 little 5, as well as I say, paragraph 12, paragraph 41. Also, actually, paragraph 60, MS 274. Maybe, please, if the court just looks at that very briefly. Paragraph 60 of the FTT's decision, MS 274. Now, this is an executive, Mr. McClelland, and he's being asked questions. But it's just a very tailpiece. Where he says, in turns, if the money hadn't gone in, I would have left.
Last sentence, yep. Well,
And just while I'm at it, if the tribunal, if the court, please, looks at MS 1157, this is a board minute. And this is relevant, I promise. It's Appendix 2, and it's the very, very last page of Appendix 2. My Lord Carnworth asked Mr. Thornhill this morning where this notion of constructive obligations came from. It's paragraph 2, that's where it comes from.
Sorry, this is...
This is a board minute. I'm sorry, my Lord, do you have
very
it?
last page.
It's the very, very last page of Appendix 2.
Very last page, very last page, yes, thank you.
Appendix 2. 23rd June 2006.
I'm so sorry.
23rd June 2006.
Yes, exactly.
It's paragraph 2.
And 3, as it happens. So the employer thought it had this, what it called a constructive obligation. So, in response to my Lord Reid, absolutely, so far as the executives were concerned, of course, the bonuses were discretionary. But my respectful response, my respectful response to that is, so what? If I had paid you, you're taxable. To avoid tax, I'm paying a trustee, which you're happy with. Is the source still work done? Tick. Is there a causal connection between work done and the payment? Tick. And as it happens, is it for the year in which the payment is made? Tick.
Yeah. Yes, and you would say that's reflected both in the description of the contributions as discharging a constructive obligation and also in treatment as part of the cost of the company's earning its profits.
Absolutely.
Yeah.
Absolutely. So with the court's permission, if I can then turn to the authorities, and I hope I can take these very short, because we've discussed most of them.
Yes?
The court does not need much in the way of submission from me about construing facts realistically. There's a useful phrase, actually, all that time ago in Ramsey, where Lord Wilberforce talks about the relevant transaction. And it's actually useful because it gives precision to this notion of purposive construction and realistic appraisal of facts. The notion of relevant transaction is one where you identify who are the parties, what's the subject matter, what's the consideration price. It's a very useful phrase to make this notion of purposive construction precise. Now,
And here you're talking about the purpose of construction of what? The word emoluments?
well, therefrom.
From.
Yeah. Or in section 9, from. And when we get, I'll take this short, when we get the PAYE regulations, payment.
So where do we go to first on the authorities?
Please, can we go to Smith and Stretton, which is divider 18.
Yes.
Page?
Oh, I'm so sorry, my lady, 1797.
Oh, right. Right.
So this is the beginning of the judgment of Mr. Justice Channel, and if I pick it up just where he asked the question, whether, if the court has it, the true effect of the scheme is to increase the salaries, imposing at the same time an obligation on them to deal with the portion of the increased salaries in a certain way, or whether the true effect of the scheme, when you look at the substance, is not to increase the salaries, but give to the masters upon their ceasing to hold their position gratuities or allowances. That's the point. It's saying, well, look and see what the bargain is. Is the reward obtained at the beginning when it's paid and it's an increase in salary, or at the end? And just to be clear as to what we're talking about, if you turn back, please, to page 38 of the report, it's 1794. MS 1794. These are the payments which were at large. These are the payments which were being scrutinised, as it were, on the way into the fund. C, a further addition equal in amount, so on and so forth.
Yep.
But they were subject to condition 5. And condition 5, it's at MS 1795. And it imposes contingencies. So they may not get anything.
Yep.
Nevertheless, held, it was the application of a salary, because what was being paid was a monetary amount, a specified monetary amount. That's the difference between this case and Edwards and Roberts. Picking it up at page 42, MS 1798. Bottom of the page.
Passage we looked at, yeah.
Yes, except you were taking the word receivable.
Yeah.
What you didn't see was the rest of it. Is not the less salary or wages taxable because for some reason the person who receives it has not got the full right to apply just as he likes. Now, the point about Smith and Stretton is that there was no actual receipt of the pound notes by the Dulwich masters. but as I say, nevertheless held increase in salary. Let's look at Hadley, please. 27.
Yeah.
Short point. Page 530 of the report, MS 1990.
Yes.
At F, this is the charging provision in New Zealand.
Yes.
And the charge is on every person, all income derived by him. Now, why is that so different to therefrom?
So you say it's analogous in the sense that it's looking to the source of his income.
Absolutely right.
Yes.
Absolutely, my lord. The appellants have said repeatedly, this is New Zealand and it's all different. Well, no, it's not. As it happens, the reason that the case would have been decided differently in Australia, you'll see at page 532, not that interesting. It's simply because Australia treats the source not as the personal exertions of the partner, but rather the partnership. So it's a different source.
Yes.
But at 533, between E and G, the conclusion of the Privy Council, which again put short, if it's your work, the money is taxable in your hands, who cares who receives it, I say, is equally applicable here. Derived from, derived by him. Yes, I do say, that is not at all a different test to therefrom or from. Edwards and Roberts, 19. The court will see at page 628, MS 1814.
Yes.
That the bargain here talked about a salary and then separately the creation of this conditional fund. And put short, it was a percentage of the profits made by the company.
Right.
And then turning over the page, 629 MS 1815. The trustees had the option of either paying over the money or the assets in which they'd invested. The court will see that it's capital B. And the essence of the case, one can find actually in the decision of Lord Justice Romer, page 640, MS 1826. Because what was at stake in the case were the small sums paid over the years into this conditional fund, were they the salary, or was it the shares that the employee got at the end? Was that the salary? And what Lord Justice Romer said at 640 is this. As I read this agreement and reading it in the terms of what in fact happened, it appears to me that it amounts to this. The company agreed to pay to the employee during his service his salary at the rate of £425 per annum, but agreed as an additional inducement to the employee more effectively to perform his duties and assist in promoting and advancing the interests of the company, that the company would in the year 1927 pay him the sum of £1,639. So they're saying that's what the bargain was. We'll pay you salary now and something in 1927. And it's for this court to conclude whether the bargain between the employer Rangers and the footballers on the one hand and the executives on the other was really to say, we'll pay you salary and the hope of a loan at interest. Or, no, we're going to pay you salary. We'll pay it to the trust, and good things will happen thereafter. Same with the bonus. Now, this is not, contrary to what might be hinted at in this court, a novel approach. If, please, if the court looks at a case called Collins, Divider 57.
Yes.
Now, this is capital gains tax. But it's exactly the same principles at play. So you've got a director who sells some shares, and part of the consideration is paid into a pension scheme. And it was important for the payer that it was paid into a pension scheme because it wanted a deduction for paying into a pension scheme. If the court please looks at paragraph 24. This is a decision of Mr. Justice Lancelot Henderson, as he was. So he goes through the contract, as all the cases do.
Yep.
But put short, the court can see, it's the third sentence that begins, it was clearly hoped, if you see that.
Yes.
That the pension contribution would be allowable as a deduction for corporation tax purposes. So it was important that the slice of consideration paid by the company for the shares that went into the pension fund was seen as going to the pension fund, but nevertheless held colloquially, so what is still part of the consideration for the shares? It's all a matter of construction of the contract. That is right.
So I'm being very dim. I'm not understanding what this has got to do with it. What's the point? What
The point I'm making is this, that part of the consideration in Collins was paid to a pension fund, not to the seller of shares.
Yeah.
It was also important that the payment was seen as going to the pension fund rather than to the individual who sold the shares, because the company, the paying company, the acquirer, wanted a corporation tax deduction for paying money into a pension fund. Nevertheless, held that it was consideration for the shares in the hands of the individual disponer. And in my respectful submission, it's not a sign that the tax analysis has gone wrong, in that the case might seem so simple. In my respectful submission, if a footballer is recruited on the basis of a net of tax single package and doesn't pay tax on a slice of it, that's a sign that the analysis has gone wrong. Equally, a discretionary bonus. The touchstone is source. The touchstone is a causal connection. And so picking up Ford and McHugh, with the court's permission, I'm going to pass over Heaton and Bell for this reason. I'll look at, of course, I'll look at it to address any questions the court has on it. There's a but coming, which is this. Heaton and Bell was asking, did this particular employee, did he get a wage or did he get a car plus a wage? So when it was asking questions of entitlement, it was asking what he was entitled to. Nobody could give a fig about the question of entitlement in order to find a tax charge. Heaton and Bell has got nothing to do with this case, except to say as a matter of approach, one construes the contract and construes it realistically and doesn't get taken in by disguises, all that.
So you're not going to take it to it because in a sense you say we're looking for something that isn't there.
Yes, and
Okay.
the court didn't see anything
No,
frankly, that helped the court in this case.
Understand.
Ford and McHugh, 33.
Yes.
Now, as I say, and I've trailed this, so again, it's not going to, this is really not going to take very long. In Ford and McHugh, the money goes in, no argument, in the sense, quite literally, no argument and no analysis, that this was an application of salary. So but the revenue did say, aha, there's a benefit, that means it's earnings. Held, no. Then looking at my Lord Hodge's judgment, paragraph 16, MS 2111. So these are the reasons why the revenues argument was held to be wrong. One's this double chargement, and the court has actually got my submissions, I think, as to why there's no double charge in this case. If I'm right that the payment into the main trust was the true reward, and everything else thereafter was a fructification, an application of that salary once paid. The salary is paid once, whether it's a bonus for an executive or the payment under the side letter for the $2. Now, again, in parentheses, it was put to this court, there are charges all to do with the cheap loan provisions. What I say about that is this. One, the charge on cheap loans arises if the loan is in fact a cheap loan. The revenue has not raised an assessment because it's not at all obvious these loans, at least on their face, are cheap in the sense of bearing up an uncommercial interest rate. Two, the loans have also got to have a causal connection to employment before they fall within the cheap loan provisions. And with the court's permission, I shall deal with that when I deal with benefits in kind. So if it's right that the loans merely fructified a tax scheme, there is no causal connection anymore between those loans being made and the employment. So forget a double tax charge. Paragraph 17. Now this is important because enormous pressure is put on this notion of receipt, what's received. Now, in my respectful submission, it's a mistake when one ascertains the reward to look at, as I say, either exclusively from the perspective of the employee or from the perspective of the employer. What one asks is, what's the reward? Now, that is what I think, I'll be corrected if I'm wrong, my Lord Hodge meant in paragraph 17. That the revenue can't simply say, aha, there's a benefit, but there was a money payment, and so that somehow it follows that there's earnings. Because what my Lord Hodge says in paragraph 17 is, but what's been received? If you unpack that, is what was the true reward? And there was no foundation. There was nothing to found an argument that this was an application of salary. So of course one has to use as a cross-check in ascertaining what the reward is. What does the employer pay? What does the employee receive? In this case, he receives the satisfaction knowing that the payment's been made to someone who's going to help in a tax scheme. Paragraph 18, the contingency. Well, there's nothing contingent about the payment being made to the principal trust trustee. It was in fact made. That was the bargain. If you're a footballer, it was enforceable by a side letter as a matter of contract. If you're an executive, it was discussed with you. That's common ground. It's a finding by the first-year tribunal. And the bargain was, instead of, as we have done over the years, paid you a bonus, we'll pay it into the trust. And nothing contingent about it. It's a discretionary bonus, but as I say, my response to that is that's got nothing to do with this case. The question is the payment a taxable emolument? Yes. And that's why I say that Ford and McHugh is a straightforward application of Tennant and Smith, and indeed Wilkins and Rogerson. In Tennant and Smith, the consequential benefit, sir, the bank employee, that he didn't have to pay rent, that's not enough to make something taxable. It would have been different if he could have returned what he got to account. That's a whole separate conversation. In Wilkins and Rogerson, the opportunity to get a suit was the reward, as a matter of construction of the bargain, not the £15 paid. So it's not good enough, and it's wrong, it's simply wrong, to cite Wilkins and Rogerson as authority for the proposition that payments made to third parties can't be taxable. That's nonsense, if I may say so. Smith and Stretton makes that clear. Edwards and Roberts makes that clear, because they were simply trying to find out whether it was a salary or something else. So in no view is Wilkins and Rogerson authority for the proposition that payments to third parties are not taxable. Question is, what was the employee getting? A suit or something else? Money, held a suit. It cost the employer money to buy that suit. Not relevant. Because the bargain was that he was getting a suit. The question here is, what's the bargain? I've done that point to death. The notion that the bargain was the hope of a loan is not a realistic appraisal of the bargain between Rangers and the employees in this case.
You could say that in the Wilkinson case, the employee was getting the £15 that was being paid, or you could say he was getting the suit. And I got the impression that one of the law lords might have said he was getting the £15, but even if that's right, it doesn't impinge on your argument.
Absolutely not. And it's a matter of...
a matter of analysis.
Absolutely right. Yeah, I think, the notion that I'm going to recruit a footballer or anyone to say, well, actually, I'll pay you 100 and a loan, maybe. That's a silly proposition, if I may say so. They were willing to take the risk that the trustee wouldn't exercise his discretion in the way that they wanted, and that's different.
Well, I suppose you'd say on that analysis, they weren't, as it were, giving him the benefit of the trustee's discretion. They were giving him the money that led to the trustee's discretion. Or they were paying the money which led to the trustee being able to exercise his discretion in relation to that money.
Yes, because the tax scheme had to play out.
Yeah.
The money, the salary once paid, had to be accessed. Mr. McCann's words, not mine. I think that's in paragraph 52 of the FDT's decision. Had to be accessed by the employees doing the scheme. And the appointment under the sub-trust and the loan thereafter was the means by which the payment of salary was accessed. My Lord Carnworth asked about Dextra. If I could look at it, please. In my respectful submission, it doesn't add anything to this case, but I ought to look at it in response to my Lord's question. I'm looking at it behind divider 28. MS.
Yes. Yes.
MS.
I see, yes. MS 1995.
Yeah. It's 28 and 29.
And
We're looking at in the Commissioner's...
we were looking at the Commissioner's decision at tab 29 with Mr. Thornhill.
Yes, the relevant bit was really at MS 2049, 2048 to 9.
Well, certainly. If you want to look at it behind divider 29, then of course that's MS 2.
Well, that's just where we were showing it before.
Of course, 2045.
Thank you.
So that, and if you look at little 5,
This is on page.
it's on page 419, MS 2045.
Thank you.
On the 21st December.
Exactly.
Thank you. Just above letter C, right?
If you give me a moment, I just need to find out where I've marked this up in the...
You want to look at it back at the other place. One's a tax case and one's a Simon's tax case.
Yeah. It's just annoying because they're neitly set out in different subparagraphs at 28 and 29.
Okay, let's look at
each
it at
other.
28.
No, it's all right. I've found it now.
If it's easier, we can do it later. I see entirely what you mean. It is a more friendly.
This is a really difficult thing to read.
Paragraph 14 is one of the most unfriendly paragraphs I've seen, yeah. Whereas
We go back to the tax cases then.
it does look much better.
Yeah,
You're
this
absolutely
is really not worth all this effort because the point I was making was simply this: the contributions were made on 21st December 1998, and the resolution and the request of the trustees was made after that on 29th January 1999. And that's why I said in response to the question asked by my Lord Carnworth, did the diversion of profits argument arise in Dextra? No, it didn't, not in the present forum, because at least on the face of it, it couldn't be said that the dynamic was the same. It couldn't be said, I'm going to pay you 100, I'll pay it to the trust, because the money had gone into the trust already. What there was the same argument as being run in this court, that the appointment onto the sub-trust was effectively an appointment to the employee. That's a different argument, which I'll come to.
right.
But that's the lot on Dextra, because it doesn't really add anything to this case on this issue.
Thank you.
Like I say, the money was tipped into the EBT, and then, as a reward for past and future services, the trustees were asked.
Could the same have been done as a matter of mechanics in this case? Probably couldn't it?
Probably. Then it would have been a different case, and it may be that was less attractive to the footballers and the executives.
Anyway, that's not what they did. So.
That's not what this case is about.
Do you have a position on whether Dexter was right on this point, whether Dr. Avery Jones was right, or is it, you say, simply unnecessary for us to decide that on your analysis?
I say it's a question of analysis in each case. So I don't want, and I'm not making a submission that on this point Dexter should have been decided.
No, I'm saying you're neutral, effectively. You're saying it's a question of analysis in an individual case.
Exactly.
And all we're concerned about is the right analysis of this case.
Exactly.
Thank you.
Do you agree that Semper was wrong, do you?
Oh, absolutely. Semper was wrong on a million levels.
That's a bit over the top, isn't it?
No, I'm not going to work myself up into anti-Semper rage. I just mean that Semper was wrong because in that case, the employees had the choice. I wasn't going to show you it because it's not really worth it. But the employees had the choice of deciding whether the money went into the EBT or they just took it as salary. Now, point one, why that isn't simply money at my unreserved disposal, I don't know. Ridiculous, in my respectful decision by the special commissioners. Two, of course then, if I have a choice of whether the money comes to me or goes to the trustees as part of the tax scheme, of course I say that's a diversion of salary. As it happens, I say you don't get that far. If that money is not at my unreserved disposal, and even if it's a right to a future payment, in my respectful submission. Now, points were made about the revenue's generosity in their practice, in their manuals as to what does or doesn't count as a salary sacrifice. I've got nothing to say about that. And in my respectful submission, neither should the other side have anything to say about that. If the revenue's been overgenerous, they've been overgenerous. Similarly, I've got absolutely nothing to say, and I'm glad I don't because I couldn't face looking at them, the disguised remuneration provisions, the finance bill provisions. And the revenue's got nothing to hide. It's not just a submission that one shouldn't look at future legislation to construe today's legislation or previous legislation. It's a quite simple proposition. The revenue might enact all sorts of things to protect its position before litigation is finished. So what? So practice as to what the revenue might have in generous bracket, perhaps over generous close bracket, practice as to what counts as salary sacrifice, irrelevant to this case. And the provisions of the disguised remuneration code, wildly irrelevant. If I could look, please, at Brunby and Milner, at divider 22 and then at 23.
Yeah.
And the reason this is important is, one, as it happens, it makes good my submission that, of course, the test is a causal one between the payment and the employment. And second, it actually deals with the variant of my diversion of earnings submission, that if, and I don't quite see how, but if there is an insufficient causal connection between the work done and the payment made to the principal trust, by the time that the payment is made from principal trust to sub-trust, if the true explanation is that isn't really a mere fructification of the tax scheme, but the beginning of something new, then that payment ought to be taxable. Because if and only if there is no causal connection between the payment from Rangers to the principal trust, so really is if and only if, a payment from the principal trust trustee to the employee is taxable, because the employee is only a beneficiary because he's an employee. So a payment made instead of to the employee to the subtrust, where the employee chooses the beneficiaries, the employee has a letter of wishes, and it was triggered, the appointment was triggered, the court may recollect this, as it happens, by the loan application by the employee. If the court remembers, it's at paragraph 47 of the FTT's decision. The way this scheme worked was that the principal trust trustee made the appointment onto the subtrust on receiving the loan application. Now, that's more than a jury point. The point I make here is that if and only if there is an insufficient causal connection between the payment going in, onto the trusts of the principal trust, there must be a causal connection between the employment and the payment being made from principal trust to subtrust.
I'm not sure I follow that. I must say, I mean, aren't we then back into the territory of sort of but for and causa causans and all those things? I mean, the payment at that stage arises out of the terms of the trust.
Well, no, that's why I'm going to show the court Brumby and Milner. The reason is because the terms of the subtrust were asked for by the employee in the letter of wishes, which the court has seen. The payment was triggered, as I say, with the receipt of the loan application. That's just the admin of the trust. So there is a causal connection between the employment and the payment from main trust to subtrust. As I say, the better view, and this is my primary position.
Because what you've just said is an alternative argument.
Absolutely.
Yes.
No, I understand it's an alternative argument. What I don't seem to assume that it follows automatically that if you're wrong on argument one, you're right on argument two. And
I'm not saying that.
Persuaded about that.
I'm not saying that. I'm saying if I'm wrong on argument one, in my respectful submission, I can't quite say how I am, but if I'm wrong on argument one, then it doesn't follow axiomatically that I must be right on argument two. I'm saying that if you then look at the picture as to what happened on argument two, if that isn't explicable as a mere fructification of the tax scheme, but as something which is new,
but we then get into all those arguments that I recall from cases like Wicks and Firth and so on as to whether it arises out of the employment or something else.
Yes. And the reason I'm going to show the court Brumby and Milner was that this sort of conversation is precisely the conversation that was had in Brumby and Milner. In Brumby and Milner, you have a trust for the benefit of employees. The only reason they are beneficiaries is because they're employees. The trust has to be brought to an end because of a merger of the company.
Yeah.
Nobody foresaw that.
Yeah.
And so that's the whole point of that case. What was said is, well, the source isn't the employment. The source is something else. Held no. So absolutely.
Shall we just look at see what they said?
Well, yes. But just before we do, if I may just pick up what my Lord Hodge and what my Lord Reed said. Of course, this is an alternative formulation of the factual matrix, because it is for this court to analyse properly in the light of the tests in BMBF, UBS, all that, to conclude as a matter of law what the bargain was.
Yes, I mean, as I understand your alternative is if there isn't a causal connection with employment by the payment to the principal trustee, then when the employer directs that trustee to put funds into a subtrust in response to the employee's request, at that point you have the causal connection.
Absolutely. It's either merely fructifying the original causal connection, which is my primary position,
Yes.
or it's a causal connection in its own right.
Yes.
And
Yes.
looking at 22,
Yes. Which page do you want to go to?
it's page. I'll take this very short. It's page 31 of the report. It's MS 1890.
Thank you.
Excuse me. And the reason that we're looking at Lord Russell's judgment in the Court of Appeal is that it was expressly approved of in the House of Lords. And at page 31, right up to 33, MS 1890, 1892, you're told broadly what the arrangements were. Employees were made beneficiaries of the scheme, not a scheme in any pejorative sense, it was just a trust. And then you're told at page 33, between C and G, MS 1892, because the company was the subject of a merger, that to liquidate the scheme. Question: were these termination proceeds taxable? Held yes. Page 34, MS 1893. And this is what picks up and addresses some of the observations made by my Lord Neuberger. At the bottom, Hochstrasser and Mays. In my judgment, the authorities show that to be a profit arising from the employment, payment must be made in reference to the services the employee renders. That's the causal connection. That's why the reimbursements in Pook and Owen were not taxable. They couldn't be referred to services. And it's repeated at page 35, MS 1894, just above F. The receipt has the taxable quality of remuneration or reward for services. That's what gives the payment a quality of emoluments. And that's why, in my respectful submission, in the exchange I was having with my Lord Neuberger and my Lord Reid, it's all to do with source, because that's what the Crown argued at 35, right at the bottom.
Yeah.
And it's because at page 36, MS 1895, the payments, that's the termination payments on the liquidation of the scheme, were taxable. Because this is all put in the negative, because they're disagreeing with the special commissioners, but the payments were from the employment. Just because the company took a decision to terminate the scheme didn't break the causal connection. And the essence of the decision is that between F and H, it appears to us that the scheme was one scheme based fundamentally on reward for services by the employees, and the fact that after the final payment there was no more by way of bonus to look for does not relevantly distinguish that final payment. They were looking at interim payments and final payments. Moreover, there are two particular points which indicate that in truth these final payments were rewards for and with reference to services. That's the test.
Thank you.
First, pensioned ex-employees who, ex hypothesi, would not have been such because of the services they had rendered were brought into the class of recipients. Second, if an employee who was at such a date of determination of the scheme and would otherwise qualify was in the period between then distribution dismissed, he was excluded. So all they're saying is, don't tell me this payment didn't have the relevant connection to your employment. Now, please, with the court's permission, if I look at the House of Lords decision behind divider 23, and again, this is not going to take very long. At page 1099, MS 1899, the very last sentence of Lord Wilberforce's judgment, he agrees with Lord Russell. At page 1100, MS 1900, this is making the point again, and it's a point now I think that the court is well seized of, between C and G. The court is talking about source because it's saying, look, in a case like Hostrasher and Mays, when a payment's made, not in the capacity of employee, but in capacity of someone who's spent money, all right, then that's not taxable. Because that was paid to someone in their what was called the personal situation.
Didn't Lord Wilberforce summarise the situation quite neatly at the bottom of 1898? The only question in this and in many similar cases, reading short, is whether the emolument can be said to arise from the employment or office.
Yes. Yes, my lord.
Yes. That is the point. That's your source point, ultimately.
Absolutely. And the reason that Brumby and Miller is important, as I say, not just because I rely on it for the alternative formulation of my diversion of earning submissions, it's also the basis on which we say that what I'm going to call the protector point, I have to make that basis good, that if the trustee of the principal trust had paid money direct to an employee beneficiary, that would have been taxable. As I say, that seems to be common ground. If I've been wrong so far on my primary submission, it's still a diversion of earnings if instead of paying to the trustee, it was paid to a subtrust. And just so that the court understands this is not a fanciful submission, if the court looks, please, at two things. A side letter of one of the footballers, say it's Mr. McCann, so at page 510, page 6, MS 675. That's a letter, sorry, that's a letter of wishes. Page 510.
675.
MS 675.
This is one we looked at this morning.
Yeah, and you'll see that these are it's a very strong letter of wishes, saying to the trustees, please do what I tell you.
The 676, is it? Or
5.
675.
676 is the letter of wishes, I think, in my copy. It's the letter from Mr. McCann to the trustee.
Yes.
Sorry, you're quite right. You're absolutely right, my lord.
Yep.
676. As it happens, a side letter. Just one point, so the court's seen it. 675, as my Lord Hodge rightly said, is the side letter. Please may the court also look at a side letter of Mr. Tommy McLean. And I think that's MS 744.
Andrew Dixon. Yes, to Tommy McLean, yes.
If you give me a minute, please.
That's
And see this.
letter to Mr. McLean.
Yeah, and to see this, it demonstrates and betrays what the scheme's ought to do, because it's saying, and if this doesn't happen, don't worry, we'll pay you.
Yes. Yes. Last three lines, yep, thank you.
So where I've got to is the payment of salary is paid once, it's paid to the principal trust, failing which the payment of salary is paid once, it's when the trustees have paid it onto the subtrust. Because if the court looks at the tenor and dynamic and colour of the side letter and the letter of wishes, that is a diversion of earnings. That's an alternative formulation of the facts. That is absolutely right. So that it's a matter for this court to come to which one is right.
Understand.
To address the bargain as a matter of law. So we've done all that. We then move on, because this is why Brumby Milner is also relevant. Say I'm wrong about all that. If a payment had been made by the principal trust trustee to a beneficiary, absolutely, that's taxable. If the payment made onto the subtrust is one which the employee, as protector, could actually access absolutely, then that is money at his unreserved disposal. This court is familiar with Garforth, and in my respectful submission, that case is right, that money at the unreserved disposal of an employee is properly viewed as paid to the employee. And so that then leads on to the protector point, because if it's right, if I'm wrong about everything else, but if it's right that the employee could, by reason of his powers as protector, have got rid of all the other beneficiaries, appointed himself as a sole beneficiary, and then brought the trust to an end, that is a payment to him. And with the court's permission, my learned friend Mr. Herbert will address the court on the protector's powers. Those are my submissions on the main points on the two formulations of diversion of earnings, unless I can assist the court further.
You've dealt with the benefits point, have you?
No, I'm going to do that after Mr. Herbert.
Yes, so there's one other passage that might be relevant in Brumby at 1900, where Lord Kilbrandon looks at the statutory words and quotes from the famous passage of Lord Reed and Laidler. Mm-hmm. I mean, that you would say, I think, is consistent with your view.
It's all consistent, my lord. It would be a sign my analysis has gone wrong if I had to say all the cases were wrongly decided. Sorry, I'd forgotten, and I'm grateful to Ms. Belgrano. My Lord Carnworth had asked what is in now section 62(2)(c), any profits whatsoever, had ever been discussed anywhere. The answer is yes, in Tennant and Smith, divider 17. And the court will find it at page 167 of the report, MS 1785.
1785, thank you. Yep.
And the court will see it, MS 1785. This is the Lord Chancellor, Lord Halsbury, and he's talking about the phrase salaries, fees, wages, perquisites, or profits whatsoever. It's the second last paragraph on the page, if the court has it.
Yes. Yes. Thank you.
So it doesn't take one much further.
No, not really.
Thank you very much. Can just get me right, that we've dealt with in your first alternative argument so far, which is that the payment comes at the stage 2, as it were, and does that have exactly the same consequence in the amount of tax?
Yes.
It does.
Yes, because it's the same amount that's paid.
Same amount. And in terms of the PAYE, the time when that becomes payable?
Yes, with the court's permission, what I was going to do, once Mr. Herbert had addressed you on the protector's point and I've addressed you on the Section 154 benefits, was deal with PAYE at the end.
Okay.
But of course, my lord, that was the whole point of this scheme, that all of the money tipped in for each employee would be tipped into the sub-trust for that employee.
Yeah. Now, I'm just trying to keep clear as to each alternative argument where it sort of takes us.
It's on exactly
It
the
gets
same
slightly
amount.
more obscure as we go along, I think.
Yeah. But it's exactly the same amount. If you take 100,
All right.
alternative
I'll take your
employees
word for
100.
it for the moment.
If you take the 100, primary argument is the 100 going into the main trust. Alternative version of the primary argument is the 100 going in from the main trust to the sub-trust.
On the direction of the employer, maintaining the link.
Absolutely.
Yes.
And then on the protector point, it's exactly that same 100, but for a different reason, because of his powers of disposal.
Because you say you've got unreserved disposal.
And then finally, it's actually the same 100 when we get to the benefits point, because that's all to do with what the cost was of providing the benefit. But I'll come to that.
I look forward.
Oh, I'm grateful. But with the court's permission, those are my submissions on the diversion of earnings. And with the court's permission, Mr. Herbert will address the court on the protector's powers.
Thank you very much. And then you'll come back on the final point.
Yes, I will.
Thank you, Mr. Ghosh. Mr. Herbert.
My lords, my lady, just playing box and cops. My lords, my lady, my task has been flagged up as dealing with protectors, and that's certainly part of what I need to address the court on. Another part is to try to explain what I hope you will see as being the very strange nature of these subtrusts. In regard to protectors, there's little or no high judicial authority on the nature of protectors, and there's no legislation about them in this country since 1833, and even that is not relevant to anything that you're going to hear today. There are some decisions of lower courts, mostly in overseas jurisdictions, which are not authoritative here. They are, however, perhaps illustrative in maybe a useful way to show the typical way in which protectorship has developed in, I suppose, the last 50 years or so, particularly overseas, and the way in which the status and powers of protectors have been defined by the courts, by those courts. And this has led to writings in textbooks. So those are the sources of laws for practitioners now. It's textbooks and overseas decisions. But I dare to predict that this is not an appeal in which this court will find itself seriously tempted to make novel rulings about protectors generally. And the reason why I dare make that submission, as I hope to demonstrate, is that this particular trust, or these particular trusts with which this appeal is concerned, are not the normal type of trust which have protectors, and so that the status and powers of the protector in these trusts, in this appeal, with one exception, namely the power to remove and appoint trustees, are not truly comparable to the status and powers of protectors generally.
Right.
In truth, therefore, our submissions on this point are less about the general law and practice about protectors, but about what appears to be, about which there's probably little difference between the two sides. Instead, our submissions on this point are about the effect of the particular powers, particularly the power of amendment, which are conferred on the particular protectors of these particular subtrusts.
Yep.
Now, our written case on this starts essentially, under the heading, the respondent's second alternative argument starts at paragraph 76, which starts at MS number 132.
Yep.
And where it gets on to protectors themselves, start at paragraph 80 on 133. And I will, if I can, attempt to stay, broadly speaking, in line with the written case, although there are a couple of areas where I am going to go off-piste to add comments to them.
Very well.
In paragraph 80, we summarize 3 basic submissions, which we say is the basis of our criticism of the opinion of the inner house.
Yeah.
And they appear at the bottom of 133 and the top of the next page. The label protector is not itself determinative, that all powers exercised by the employee, given that label, are fiduciary. That's partly a question of labels. These are trusts put together in the context of an avoidance scheme, which is attempting to create a certain impression,
Yep.
and they use that phrase. Secondly, more generally, the word fiduciary has a number of shades of meaning, not just one meaning. And there is, thirdly, in any event, no black letter principle of law that a fiduciary power can never be exercised to benefit the person exercising it.
Presumably the terms of the trust could give him that right,
Yes.
for example. Yeah.
Yes, and we say further that the terms of this trust do, if only by implication, that the protector is given those powers in certain circumstances. So from those conclusions, it follows that the conferring of the power of amendment, even if that employee is described as a protector, it doesn't lead inevitably to the conclusion that the individual can't exercise the power to benefit himself. And if that was an assumption that the inner house made, we suggest it was mistaken, and if it was a finding, we challenge it as a finding. Now, the following paragraphs of the written case do expand on that, and I'm not going to read through or repeat that very much. You'll see in paragraph 82, however, on page 134, that it's expanded, that the label is used there, but the court should not be deceived by a mere label. The court would be permitted to be deceived by the very last line in the page, where I'm afraid the curse of the autocorrect has changed employee into employer. That should really be the employee or the provider, because it's, of course, the employee who is made the protector of these trusts. In 83, there's a reference to the Freedoms and Recoveries Act 1833, but I don't need to take you to it unless you want to see. The only thing that I might add about the 1833 Act was that the draftsmen of that were perfectly aware that it was possible that a protector could be saddled with the duties and obligations of a trustee, and went out of his way to remove that. There's a section 36 which makes it very clear that the obligations of a trustee are not, that the protector in this case does not have obligations of a trustee. And in paragraph 84, the inner house did say, and we agree that it is correct in regard to most protectorships and the typical protectorship, that this whole practice has principally grown up in the last half century. And usually the motive is that the settlor or truster's motive in appointing a protector is to reassure the settlor that the trust is going to be managed properly. And typically, it is correct that the protector is given powers to give or withhold consent to decisions of trustees. Of course, the point about that is that it's important for all kinds of reasons to know who your trustees are. And you don't want to allow the protector to be treated as a trustee by mistake. And so the protector doesn't hold the assets. He doesn't have dispositive powers usually, but he does have power to give or withhold consent to the trustees exercising powers. But as we say, that's no more than a description of typical protectorships. Now, the text goes on to talk about powers, and this is really where it gets into the question of what is a fiduciary power, and I am going to have to spend some time on that. And particularly because a little passage in this has been commented on by my learned friends on the other side. There's a sentence there which says powers may be legal or equitable, dispositive or administrative, beneficial, limited or fiduciary, imperative or permissive, collateral, in gross or appendant. And I'm afraid I would rather have seen some semicolons there so as to actually punctuate the various sort of binary choices available there. Now, this has been picked up by my learned friends in their written case of saying that in a case called Metoi, this was described as I think of an antiquated or some word like that phrase. It refers to this and says some of these classifications are now of antiquarian interest only. That's at MS 92-93. Well, and they cite the Metoi case. And if I could just invite your lordships and my lady to look at the Metoi case. It's in volume 3 of the authorities, and it starts at MS number 2334. Now, I think I should put this in context, because it's a very long judgment, and I certainly don't want to spend too much time on it. But the context of the case was, it was an occupational pension scheme, and it contained an actuarial surplus. And in those days, that wasn't unusual. But the employing company had gone into administration and then liquidation, which meant that the pension scheme had to be wound up. And under the terms of the winding up, they had to secure all the basic benefits. And then there were two clauses at the end. One of them gave the employing company a power to enhance the benefits of all the members, pensioners, etc. And finally, any remaining surplus had to go back to the employing company. Now, the particular issue with which this passage of the judgment is concerned was whether the power was fiduciary or not. And what the judge decided was that the power was fiduciary in the full sense of the term. Now, that rather implies that there's a type of fiduciary power that is not in the full sense of the term, and that is indeed the case. And in fact, although the power was, well, because the power was fiduciary in the full sense of the term, It had to be exercised for the benefit of the members, etc. The person exercising the power was the company in liquidation, but it was obvious that the administrators and or liquidators of the company were not in a position freely to exercise that discretion, and in fact they admitted that they would choose not to exercise it at all. But the judge decided that this was a fiduciary power in the full sense of the term. The company and its directors and so on were not in a position to exercise it. Therefore, the power had to be executed, the power had to be exercised by the court itself. Very unusual result. In fact, what happened then was that the case was adjourned for submissions on how the court should exercise the power, which never happened because the whole case was settled on appeal. Never got any further so far as the law reports are concerned.
Considered quite extensively in Futta, wasn't it?
Yes, it has been considered from time to time, particularly in pension cases, including about the aftermath of the thing. But in any case, the passage that I want to refer to is on page 2360, MS 2360.
Yes.
And starting about halfway down the page,
Yes.
he refers to the question about this, about whether this is a fiduciary power. And then he refers to Mr. Walker, who was leading me as it happens, now Lord Walker, who was acting for the trustees. And he pointed out that so to express the question is in a way to oversimplify it, because there are different types of power described as fiduciary powers. And he goes through what is described as a wide-ranging and illuminating discussion about the law about fiduciary powers. And that division that is mentioned in our written case appears around about letter F. And he talks about the ones about powers appendant and appurtenant. He says that is now of antiquarian interest only, and he doesn't disagree with that. But then he goes on at letter G. Mr. Walker suggested a more pertinent classification, which I accept, of fiduciary discretions in 4 categories. And then he goes through them. Category 1 is essentially a power given to a person, an individual, a dispositive power exercisable by an individual. I'll call that a category 1 power, and cut a long story short, this is really a personal power, may be limited in various ways, but it's personal. Okay. Then category 2 is what he describes as a fiduciary power in the
fourth line of next page.
Yes, that's right, the 4th line of the next page.
Yep.
Fiduciary power in the full sense. Now, what this is it's a power, not a trust, so there's no obligation to exercise it, but there is an obligation to consider exercising it from time to time. Usually, it's conferred on trustees of a settlement. Sometimes other people, and in fact, there were mentioned the managers of a unit trust. I'm sure your lordships and my lady will be aware that in unit trusts there are usually 2 companies involved. One is the trustee and the other is the manager, and most of the power is given to the manager.
Yep.
Then the 3rd one is a rather curious category. This comes a little bit above letter E. Comprises any discretion which is really a duty to form a judgment as to the existence or otherwise of particular circumstances. And there are some examples there, and I could say very quickly, there's not really a power at all. It's an authority to make a decision of fact which is relevant to the trust in some way. And then category 4 comprises discretionary trusts. Now these are trusts which do have to be executed. There's no question of the trustees not doing it. They have to, it may be to distribute income, distribute capital or whatever. They have to do it, and if they refuse, the court can step in and execute the trust for them. The same is true in a sense with the fiduciary power in the full sense in the 2nd category. And in fact, that's what happened in the Metoy case. Because there was a power, it didn't have to be exercised. The company, if free to choose not to exercise it, was permitted to do it. But since it was incapable of exercising it properly, the court stepped in and said that it would exercise it itself. Of course, the court might, after hearing submissions, have decided not to. But we never got that far. Now, those are the four classifications, and I have said number 3 is not really a power at all. Number 4 is a discretionary trust, not a power. So the two important things are categories 1 and 2. And 2 is really what the authorities all talk about when they talk about a fiduciary power. It means a fiduciary power in the full sense. A category 1 power is, you could say, fiduciary in a limited sense. That limitation being that the donee of the power does not have to exercise it, doesn't even have to consider exercising it, and is perfectly free to release it. The only fiduciary element to it, really, is that the rule about fraud on the power applies to it, so it can't be used for a foreign purpose. Now, essentially, what our submission is that the power of amendment in this case is a category 1 power, not a category 2 power. Now, going back to our written case, paragraph 87 summarizes the principles and features which normally apply to a fiduciary power. It's usually conferred on trustees or some other description of appointors. The donor trustees may not ordinarily exercise the power in favour of themselves. Donee is not obliged to exercise it at all, but he must ordinarily consider exercising it from time to time. It can't be released or abandoned, and the power is subject to a doctrine of fraud on the power, and there's an explanation of what that means. In regard to category 1, it's only the fraud on the power point that applies. Now, all of those 5 characters can be regarded as the normal badges of a fiduciary power in the full sense of the term. And almost any power conferred on trustees carries the implication that all those principles may apply to the exercise of that power. Even then, there are exceptions, which I don't need to labour tremendously. They're summarised in 89 of our written case. The doctrine of fraud on the power, for instance, doesn't apply to the revocation of an appointment, even by trustees, or the release of a power. And, of course, the trust instrument may expressly provide that the trustee may benefit from the trust. And we add, at the end of that paragraph, that the trust instrument may impliedly authorise a trustee to benefit himself, as where the trustee instrument appoints one or more objects of the power as a trustee. And then in 90, the same constraints don't apply to a category 1 power. Now, moving on from there, the way that the textbook describes it is interesting. It talks about limited powers. It uses that phrase limited power rather than category 1 power. But it says, unless the power is also fiduciary, and except where the power is fiduciary, there's nothing to prevent the donee from releasing it. So that rather illustrates the sort of dual meaning of fiduciary. And what I urge in this court is that we attempt to use fiduciary, if possible, as meaning fiduciary in the full sense of the term. Now, how do you tell whether a power is fiduciary or not? That's the next question. And again, in paragraph 92, Lewin, which is a leading textbook on the subject, it says powers may be classified according to the constraints or duties, if any, affecting the donee of the power. In other words, it's not a question of saying, oh, well, the power is fiduciary, and then automatically applying all characteristics to it. It's a question of examining the scope of the power as a matter of construction in the context of all the other provisions of the settlement, also thinking about the identity of the donee, which is, again, a question of fact, and other admissible facts relevant to the construction, and then try and establish and try to apply the things, the principles. And repeat, let's not be blinded by the name fiduciary. Now, what I want to do at this stage is to show you a contrast, and I think I've got time to do this before 4 o'clock, a contrast between a normal type of trust having a protectorship and the particular ones that we're dealing with in this appeal. And I want to just take an example, which is also in volume 3 of the authorities. I think it happens to be the first one in my learned friend Mr. Thornhill's authorities mentioned in his case. It's called Centre Trustees CI Limited against Van Rooyen. And it's in volume 3, number 58, MS 2611. And I don't think I need to take it very long. It's a decision of the Royal Court of Jersey, heard before a commissioner and jurats. And you'll see that there were 2 cases, in fact. There's Centre Trustees Limited and Langtree Trustee Company, Channel Islands Limited, against Mr. and Mrs. Van Rooyen, and against Wilfred Pabst. The factual background was that these were 2 colleagues, and they'd each set up a trust, and they made each other protector of their trust. So Mr. Pabst was protector of Mr. Van Rooyen's trust, and vice versa. And all I need to do is to show you paragraph 3 of the judgment on page 2612, which shows what the Van Rooyen family trust looked like. And the court described it as a standard discretionary trust, the beneficial class comprising Mr. Van Rooyen, his wife, Colette, and their 2 children, Nicky and Jacques, the latter being the second respondents, who will be referred to as the children. And under the terms of the trust, certain powers of the trustee could only be exercised with the prior or simultaneous consent in writing of the protector. And then there's a whole list of 16 such provisions. Well, that tells you quite a lot about this trust. First of all, there were 16 discretions for the trustee to exercise, and I've already shown that there was a group of family beneficiaries. And in all of these, the protector had the power to give or withhold consent, and you'll see the sort of things they were. They weren't all dispositive, but some of them were. Most of them, I think, were administrative, like accepting onerous property, but then distributing capital at the expiration of a trust period, that's dispositive. Power of appointment was dispositive. Power to apply capital, dispositive. Transfer trust funds to another trust, also. Power to settle capital, but then administrative provisions, forming companies, well, excluding and adding beneficiary, quite important powers. And you can see that those sort of powers were themselves fiduciary powers in the full sense of the term, and that the protector, in considering whether or not to approve these powers, would also be having to have in mind the interests of all the beneficiaries of this trust, all the particular objects of the power in question. Perhaps I should have said out loud what is perhaps implicit in what I've been saying about what fiduciary means. The point about a fiduciary power is that it's judged by loyalty. It's the whole basis of fiduciary obligations is based on loyalty to somebody else. And this is a very good example here of the protector, and indeed the trustees, having fiduciary obligations to other people, namely all those beneficiaries. The context of the case was actually, I think, a removal of Mr. Pabst from the protectorship, but I don't think anything turns on the actual effect of the decision. All I'm doing is using that as a convenient example of a typical trust with protectors, or a protector. Now, what I want to do now is to compare that to what we are actually dealing with. I'm not sure I do now have time to do this before 4 o'clock, but
You have a bit more time.
I'll continue, if I may. Before doing this, and in doing so, what I would invite the court to do is to put themselves into the position of setting up this trust, what you would do. We know what the position is. There's Murray Group Holdings and the management company. We've got 100 employees or plus, and they're all going to get or be invited to join in this remuneration trust idea, whether or not for the avoidance of tax, for whatever purpose. And the idea was that, I don't think there's anything controversial, that cash would be paid to the principal trust and then to the sub-trust, and the sub-trustees would lend the money to the employee at a discount, and that would all be done. And the idea was that, no doubt it was hoped that it wouldn't attract income tax, and also that the loan would be a deductible liability in the estate of the employee at his death. So how would you go about this in considering the structure of a trust like this? Well, you'd want to avoid the employee looking like the settlor, because that would be a bit of a giveaway. And so you'd frame your trust without having such a provision. And then this loan is going to be a bit of a problem, because how can trustees justify lending their entire trust fund on terms which is indefinite, or quite possibly, certainly for long periods, where they're expected to continue the loan indefinitely until the employee dies? It's not going to carry interest, and it's not going to have any capital growth. Or it may have some capital growth if it's lent at a discount.
So it would carry interest, but interest would be payable on repayment.
On
which,
repayment, yeah.
If the employee's hope was fulfilled, would be his demise.
Yes.
Yes.
So it's a curious position for a trustee to be having to adopt. And so, as a result of that, you would not want beneficiaries too much able to complain about the trusteeship. In fact, preferably, it would be better to have no beneficiaries at all. But of course, you can't have that, because there is the beneficiary principle that a trust doesn't even exist if it has literally no beneficiaries to enforce it. But at the same time, you would want the trust to look superficially normal, not a sham. Well, those would be the kind of mental instructions that the draftsman would have had. And, well, you will no doubt see that he has carried that into effect. Bearing in mind what I've said, what I'd invite the court to look at is the terms, first of all, of the principal deed of trust, and then at one of the sub-trusts. And the principal deed of trust comes at MS 486, which is in the main bundle. And with me, there is no kind of division. I won't take very long over this deed, but I will take much longer over the sub-trust, if that's a help.
I think probably that's a convenient moment. How are we doing in terms of time?
I think we're probably ahead of time, because I think I was expecting to stand up tomorrow morning.
Oh well. sorry if you've been taken by surprise.
No, I have not been taken by surprise.
Gave no
I'm
sign.
only too pleased to be addressing you now.
In that case, we will rise now then. Thank you very much. And we'll resume again at 10 o'clock tomorrow. Good. Thank you. Court's now adjourned.